The trial of Senator Mike Duffy will resume in the new year. Closing arguments set to be heard from February 22nd until March 4th. Now, this week, Duffy was grilled under cross-examination, but the Crown did not ask about that now infamous $90,000 check that he was given by Stephen Harper's former chief of staff. Duffy has pled not guilty to 31 counts of fraud, bribery, and breach of trust. Joining me to talk about this, criminal defense lawyer Alvin Shidlowski. He's a partner at Rottenberg, Shidlowski, Jessen. Thanks for joining us today.
My pleasure.
Closing arguments, of course, the time for that final point to be made, in this case, not to jurors, but to a judge alone. What does the defense have to argue in this last round before the judge gets to deliberate what he wants to come to, or decision he wants to come to?
Duffy's counsel will focus on presumably what they will try to say is a lack of intent, that Mr. Duffy never intended to do any of these acts, that he was cajoled, that he was forced into it, that he had no choice, and try to remove the necessary intent element from any of his acts being considered to be criminal. And
those acts need that element of intent to be proven to make him guilty of it?
They do. Every criminal act must have an element of intent. The question is whether it will require the level and nature of the intent that's required, and clearly Mr. Duffy's counsel believes that they've, through Mr. Duffy's evidence, have tried to undermine and demonstrate that Mr. Duffy had no such intent. The Crown, of course, has tried to indicate that Mr. Duffy knew full well what he was doing, that he planned these things, that he was fully engaged in his affairs, and that the intent is present.
Quite often in other parts of criminal law, you don't need to have the intent if you've performed the act. But you're saying in this particular case, the intent is needed for the basis of these charges.
No, in every criminal offense, there are two elements. There's the act itself, and then one must have the intent to have committed the act, or some general intent that results in the act. And so there's always that element of intent that's required. It's always the intent in most in criminal acts. That's the challenge for the prosecution, demonstrating the intent. Almost always can they demonstrate the act, but the intent is the challenge, and clearly that's the challenge in this case.
For the bribery charges, much of that was based on an evidence of the $90,000 check that Mike Duffy took and accepted from the former chief of staff to repay these housing expenses. It wasn't brought up in the Crown's cross-examination of the senator on the stand. Why not?
Well, there's been a lot of speculation as to why not, but the simple answer to that is the prosecution didn't raise that because they could only have felt that raising it with Mr. Duffy would not in some way advance their goal. Otherwise, they would have raised it. So either they believe that the evidence that they received through Nigel Wright is enough to get them past the goal line, or they believe that they couldn't get any more from Mr. Duffy to help them push that cause forward. Duffy explained his position in his examination in chief through his own lawyer, and I'm sure what the prosecution felt was, he's given his explanation, there's nothing more to be gained by pushing him on this. We've got our evidence in, and we're going to rely on that.
So closing arguments, again, will be heard in February. There's a 2-week period, which is quite a long period for closing arguments. Do you imagine we'll have a verdict then by end of March?
I imagine that Justice Vaillancourt will work diligently. He'll want to have this done with. He knows that the Canadian people want a decision on this, and he's an excellent judge with an excellent track record. He'll want to move this matter forward, and I think we can expect a final decision. If the lawyers stick to the timelines now, finally, which they haven't until now, but I'm sure Justice Vaillancourt will, like herd cats, we'll get that decision, I expect, toward the end of March.
All right. We have Alvin Shidlowski joining us, criminal defense lawyer. Thanks for joining us tonight.
My pleasure.